Good afternoon, all. Welcome to the 16th session of my Arbitration Boot Camp series. The topic today is Med ARB Part 2, and you'll see that Dave McCutcheon is on a screen here, and I will be interviewing him. Those of you who need a little bit of background to Med ARB can view the last session that I did last month, in which I gave a general overview of Med ARB and the ADRIC Med ARB rules. But today we're going to talk to David and get some real life experience on how the process works, because it really is quite different than mediation alone and arbitration alone. Just a bit of background. I am Lisa Munro. I'm a partner at Lerners and an arbitrator at Arbitration Place. I'm also the editor and writer of Arbitration Matters, a blog series, and there's a website which contains all of the various posts on cases, Canadian cases in arbitration law, which contain some commentary. And I release some of these cases every 2 weeks to subscribers for free. This Arbitration Boot Camp series takes place once a month, usually the third Thursday of the month, and you can catch up on any webinars that you've missed. They're posted on YouTube. After this session, you'll get a recording of the session, and you'll get a list of previous Arbitration Boot Camp sessions. So if you'd like to tune in on something that you missed, feel free to do so. I generally cover topics that I think are practical and hard to get information on, so I hope you find them useful. So today I'm doing something that I haven't done on Arbitration Boot Camp before, and that is to interview an expert on a topic. And here we've got David McCutcheon. He's a former partner of Dentons Canada. He's currently an arbitrator and mediator at Arbitration Place, and obviously he does Med ARBs. He currently has his own ADR practice. He has 35 years experience in mediation and arbitration in a broad range of commercial disputes. And he's one of those people who just happens to be a resource for a lot of people who need advice, behind the scenes advice on mediation, arbitration, Med ARBs. And he's always able and willing to make himself available for that kind of advice. He's a trusted advisor to many. He's a former chair of ADRIC, so he's got lots of experience. If you want to know more about him, you can read his profile on the Arbitration Place website, which also gives you his contact information if you'd like to appoint him. If you want to know more about Med ARB generally, again, take a look at the ADRIC rules or my last Arbitration Boot Camp series. So today I'm going to ask David about Med ARB in particular, and what it is that makes Med ARB different from a separate mediation and a separate arbitration process. As usual, we'll go about 1 hour. David and I will talk for about 45 minutes. We'll give you an opportunity to ask questions. I've got both my Q&A and my chat box open. Feel free to send me questions, which I will ask of David. I have also provided to those of you who have registered in advance a copy of David's terms of reference, which I've got up on the screen, and I will be reviewing with David. So those of you who received a copy may have some questions already for him, and please put those in the chat box. This session is particularly interesting, I think, because there's not a lot of information about Med ARBs, how they work. I think there are some pitfalls for parties, counsel, and the mediator arbitrator, and I think David's terms of appointment and our discussion today will alert you to those. And we've already heard in the last session about the pros and the cons of mediation and arbitration, but what you're going to hear from David today is what it's like to actually practice in this area and things that he's learned as a result of that. So the first question I'm going to ask him is about the process. When David and I were talking just a few minutes ago, he talked about the fact that in his view, there's a third skill set involved in being a mediator arbitrator. So there's the mediator skill set, there's the arbitration skill set, and then there's something different as a mediator arbitrator. David, can you talk a little bit about that?
Sure. Thanks very much, Lisa. The big difference is that in mediation and arbitration, the practice of mediation is altered. And when you get to arbitration, it's not altered as much. But there are problems with the transition between the two. And in a lot of cases, people don't really take advantage of all the flexibility that's available in the Med ARB process. The reason for that is that in many cases, people follow a really structured approach to Med ARB. They follow the mediation first, arbitration second process. Whereas in fact, the most valuable part of this process, which is still evolving, is really structured around ARB Med ARB or Med ARB Med, and you can go back and forth between the two structures. To do that as a Med arbitrator requires a lot of skill, and you have to be very careful about the transitions going back and forth. So in my view, it's almost an entirely new concept, both for counsel and for the Med arbitrator. And something that can be taken advantage of if you're good at dealing with it as counsel. You can get tremendous advantage out of this format that you can't out of just doing it separately as an arbitration followed by a mediation.
You've just said something that many of us may not have thought about, and I didn't even think about this kind of creativity until you and I spoke before this session. And this idea of Med ARB Med or ARB Med ARB, meaning you can transition more than once through these processes, and that you need always not start with mediation and end with arbitration if the parties can't reach a solution. Can you talk about how that actually works in process in real life?
In real life, a lot of these start as an arbitration. And the reason for that is you want to stop the running of the limitation period. You need a firm date to start and immediately then go to mediation. In a lot of cases that I've been doing recently, there are discrete issues involved in the case, and you can sequence the issues through a mediation and arbitration process going back and forth. And it's really effective because in some cases you need an arbitrator's ruling, for example, an interim ruling on corporate meetings, for example, that enables you enough time to solve some of the other issues. You may have valuation issues. You may have issues that are tax-driven issues. So there's a lot of things that you can do to be flexible with the process, get the right sequence. And it isn't unusual in cases I've been in to go back and forth several times. You start out with an arbitration, lasts about 10 minutes. You go immediately into mediation and you're working with the parties on the issues. I try to get a sequence of issues early on so I understand what's important to the parties and whether or not there are issues that are conditions that need to be satisfied before you can resolve other issues. And so it's a really, really flexible process, and counsel drive it. Frankly, from my standpoint, it's never a simple case of starting with a mediation and then going to an arbitration.
If I understand you correctly, does this mean that you'll have, at any one time, you may have some issues being mediated while other issues are being arbitrated?
Yes.
Okay, so how do you explain to counsel and the parties what your role is in those circumstances? It's fairly easy to understand when you're in the role of mediator, what the expectation is regarding your role, and similarly when you're an arbitrator. But how do you make that clear to the parties and counsel when you're doing those two processes in parallel?
You have to segregate the issues. And so, for example, if you have an issue, and let's just say it's an initial issue on a mediation about what tax treatment the parties want for the result, followed by a valuation of property or a valuation of shares, you probably want to understand whether or not the parties agree on the tax treatment they want to deal with. So you're going to mediate that issue. And if they don't resolve it, you at that point are left with an issue for arbitration where the results could go several different ways depending on the tax treatment that you're going to get. So from my perspective, that could be just one of 20 issues in a big shareholder dispute or a big property dispute. And if you can get the sequence right at the very beginning, you can often make really good progress in the mediation phase.
So when you have, for example, a pre-hearing conference or a pre-mediation conference, are you requiring or requesting from counsel and the parties a very detailed listing of the issues in dispute so you can work with them on that sequence, or does that generally arise while you're working in the process, like opening a package?
I find that really good counsel have thought their way through this before they get to me. And so they really have in their mind a roadmap through the process. In a lot of cases where parties aren't sophisticated and their counsel aren't sophisticated, I use the first meeting to go through those issues one by one and make sure I've got a complete list of exactly what the parties want to deal with and their understanding of what they want by way of sequence. In many cases, what I will do is I'll have a meeting separately with each party before that first meeting so that I can canvass them as to what they think the issues are. In a lot of cases, people will forget issues. The classic example is an evaluation case. The parties don't agree on the valuation date. And so I'm trying to find out, what they've agreed on or what they can agree on at the beginning of that process. And then if they can't agree, we go to the first meeting. If they want to segregate an issue for interim relief or some early ruling, I can do it. I can switch hats and become an arbitrator on that issue and give them a result on that issue before we resume the mediation.
That means that any one time you might have more than one hat.
Yes.
So we go back to the role that the typical understanding we have of the role of the arbitrator and the role of the mediator. And one of the most fundamental concepts is no ex parte communications with the decision maker while you're in the arbitration phase. So how does that get addressed when you've got a creative process like the one you're describing?
Ultimately, I try to protect the arbitration process. And I tell the parties up front, and try to get agreement on how we run the mediation process. It's not unusual, for example, if you're going to separate out an issue, just to ask at the beginning on the record in the arbitration that the parties confirm that they're not making any complaint about the mediation on that issue up to that point. And I do that on the record, and I basically say, do you agree that the statements made about impartiality, independence, and lack of bias in the arbitration agreement, mediation arbitration agreement are still in force and applicable today?
Is it common that you start a dispute resolution process with everybody knowing that this is going to be a Med ARB? Or is it common that you start with mediation and then the parties begin to become more interested in a process that will lead to finality because there's an arbitration at the end? Which is more common?
It's about 50-50 in my experience. The classic mediation issue is you get to the end of the mediation and there's some issue that cannot be agreed by the parties. It could be the value of a property, but it's one piece of a puzzle that makes up a settlement agreement. So your final settlement agreement says the parties can't agree on the value of property A, but if they can't agree within the next 90 days, it goes to arbitration in front of McCutchen. And that happens frequently. It's a nice exit to make a mediation work, where everybody agrees on the rest of the terms, but they can't agree on some fundamental term like that just needs to be determined. Could be a legal issue. I mean, there's no end of things that, would be the tag end of a good settlement.
I know that you have the impression, and I have the same impression, that Med ARB is being used more and more frequently. how have you found it explaining to counsel and parties who have never engaged in the process what it's all about and got the confidence of them? Because the only way this kind of a process works is if they have trust in the mediator and arbitrator. How do you approach that issue? You say some counsel and parties are sophisticated and some aren't.
It varies depending on the counsel, frankly. In several of the cases I've done recently, the counsel understand it completely. They understand the strategy completely. They've worked on how to get an effective Med ARB done. In other cases, they don't know. And so I sit down with them at the very beginning and I explain the process and the potential for using the process to get a good result. And sometimes that takes quite a while, and sometimes counsel are pretty skeptical. And you just have to work with the counsel and the parties to get to a point where they either have trust or they don't.
And those that don't have trust, do they start with a, well, let's do a mediation and see how it goes kind of approach?
Sometimes. Sometimes the economics of arbitration and mediation dictate that they want to get it over with. In a comparison to family law, everybody in family law is working with after-tax dollars for their fees. In commercial, that's not necessarily true. And so the idea of doing it as economically as possible and getting a final result within the shortest time that's efficient and appropriate is really something that drives a lot of decision making in using Med ARB.
You're right that when we hear about Med ARB at the moment, it's really usually in the context of a family law proceeding where they're very experienced in this kind of a dispute resolution process. Are there some kinds of commercial disputes that are better suited to this kind of a process than others?
Absolutely. Anything that requires a legal interpretation, which mediation really doesn't give you, is probably not something you'd start with a Med ARB on unless there's some factual issues underpinning the way that legal interpretation is going to be handled. I've started out thinking that if it was something akin to a family law dispute, it's probably appropriate to use the Med ARB model because it's been so effective in family law. So in family law, you have property division and value. You have custody fights. You have fights about income. And generally speaking, anything in the commercial world that would be akin to that or within that rubric is a really good candidate for Med ARB.
So valuations, for example.
Yeah, absolutely. On valuations, that's very common. It's also common in property division, who gets what. I'm engaged in one right now where we're dividing 11 farms among 3 people. And they all have a different view of those farms. Mediation's exactly right for that. And they all have different tax circumstances.
Yeah, how do you deal with the tax issues in an ARB Med ARB?
At the very beginning, I tell the parties that they need separate tax advice. I'm not there to give them tax advice. I know there are going to be tax issues. In one case, the parties agreed to retain the same accounting firm to give the same tax advice to all the parties. And it's not uncommon, though, for parties to have their own accountants and their own way of doing things. It just becomes another issue.
Looking at getting to the jurisdiction issues and powers of Med Arbitrator. Is there anything in the legislation, international, domestic, anywhere in Canada, that restricts your ability to take on this role?
I'm going to give you a bad answer, which is not that I know.
Okay.
The Section 35 in the Domestic Act in Ontario, of course, it really requires consent of the parties to engage in this process. That seems to be similar in most jurisdictions. I'm not going to say all because I just don't know.
Yeah, I've actually taken a look at this. So that I might have an answer for you if we got into a discussion about it. And it looks to me like in the provinces where we see a lot of arbitration, for example, that like Ontario, there's a provision that says that the arbitrator should not step into the role of mediator, but it's one of the sections that parties can waive. That's how the Ontario Act works. The BC Act actually permits it. What's your view of the model law? Because it's silent. Do you have any views on that?
If it's silent, my view is the parties can make whatever deal they want to make.
Yeah, that was my thinking as well. And the importance of that, of course, is if you've got a dispute anywhere other than Ontario, this is a process that can still work, probably.
And I think it works. I mean, the one caveat to that is if you have an international institutional process, you have to look at the institution that's managing the process for you.
Yeah. How do you explain, I'm jumping around a little bit here because I've got a whole bunch of thoughts and questions I want to ask you, but I want to go back to your role and the importance that we've heard over and over again in the arbitration world of independence and impartiality. And that is in many ways the most important principle that a person in an arbitrator's chair must consider. How does that get addressed in a Med ARB?
First of all, impartiality is unforgiving. You're impartial regardless. Independence is a more flexible concept. And for example, I've been out of Denton's now for about 5 years. I'm hearing an arbitration case now where one of the parties is represented by Denton's. It doesn't come up that often, but I always ask for a waiver in those circumstances. There are other circumstances that might be perceived as a problem with independence. How frequently you're engaged by a particular firm or party. And I think Med arbitrators have to be cognizant of that. One of the real problems is that there just aren't a lot of people who are really comfortable from the neutral rule of doing Med ARB. Certainly some of my colleagues here would not feel comfortable in a Med ARB role in any circumstance.
Well, one of the things I've noticed in your terms of appointment, which I have on the screen and which I will turn to in a moment, is that you deal with this directly. So the parties understand very clearly the consequences of moving back and forth between processes. And the only way it can work is if they understand how your role changes in the two parts of the process.
Yeah, and you have to be alive to the fact that it may change. Things may happen in the process where suddenly you can't say that there's a risk that you're not independent or that you're independent. It may come into question.
What kind of material do you ask parties to exchange before a Med ARB process?
That's a very difficult question, frankly. In some cases, there's no statements that lead into the mediation. In other cases, for example, if I'm appointed under a court appointment, I'll have the pleadings, I'll have some court documents that I can work with. I generally ask the parties to do a normal mediation brief before the mediation phase begins. And the reason for that is I want to have a comprehensive look at the dispute. It may be that it lends itself to being segmented, but it may also be one of those cases where you just want to dive into the mediation and you want everybody's interests on the table. I usually ask the parties to provide me with copies of any settlement offers, either privately or on a privileged basis, because I want to know what my starting point is.
How does the Med ARB process affect the way the mediation gets run, if at all?
It depends on the mediator style. What I think it gets rid of are the bully tactics, where mediators come in and yell at the parties and try to bully them into a settlement. What it doesn't get rid of is the idea of good canvassing, realistic canvassing, and what the possible outcomes can be. What you can't say as a neutral is, I'll find against your client on that issue. You can say, what if I find against your client on that issue? And I don't think that's offensive. I would certainly do that in a mediation. So I don't think you really have to pull the punches too much. And the other thing is that you have to be careful to not forecast a result in the arbitration phase, because you may have different evidence.
Do you find that this process affects the ability or willingness of parties to be forthcoming in the way they might without an arbitration looming?
Sometimes parties are strategic, and they're strategic about things like maybe they have a witness that couldn't be available for the arbitration, so they don't want to disclose that in a mediation phase, that sort of thing. Generally speaking, I've found that the parties are pretty forthcoming all the way through.
And how does the arbitration process, how is it affected by the previous mediation?
Yes, because when you finish the mediation phase, you're starting at zero in the arbitration. So I want parties to give me a list of issues that they want arbitrated, so that I know that everything is on the table and I know what the issues are. And I also ask them if they're prepared to put any of the evidence from the mediation on the table by consent to start the arbitration. If they don't, then we start a normal arbitration from ground zero. It seldom happens, but it does happen occasionally. And at that point, you're probably saying to yourself, what do you do with all the things you've got in the back of your mind that you learned on the mediation process? And I have a pretty simple approach to that. If I was in an arbitration and somebody asked me to determine the relevance of or whether a document was privileged, they show me the document, I rule that it's privileged, then I know what's in the document, but I can't use it. I have to instruct myself in the arbitration process not to use that evidence. And I think I can do that pretty effectively. It's not that it goes away, it's just that it's not meaningful for the decision you're being asked to make in the arbitration.
So considering that, I remember talking to you about this, and you said that one of the useful things that can come out of a mediation is more background of the parties' intentions, motivations, priorities, interests. How does that play into the way the arbitration runs? And maybe you can explain what that might mean.
In a mediation process, I'm particularly interested in motivation. And I generally find that people, whether they want to be or not, are generally truthful about their motivations in a mediation process. In an arbitration process, motivation may or may not be a meaningful piece of evidence. It does help me in terms of assessing what results in an arbitration are required to explain to a losing party why they lost. And in those circumstances, you're writing those decisions, you want to make sure that you address your answers in a way that meets their expectation of how their motivation is going to be resolved. Not always easy. It's just another piece of information. It doesn't really affect your result or how you write it, but it does respect the party's interests in the arbitration process. So personally, I think it's a valuable piece of information to have in the arbitration. You can't use it, for example, to cross-examine witnesses on their motivation, which can be something effective, but that's the role of counsel. That's not a role of an arbitrator.
Do you find that all of that information affects the kind of process that gets devised for the arbitration? So for example, you said you start at square one, which may mean you start with a notice of arbitration, although it may be that the mediation briefs are sufficient to identify the issues. Then you may have certain procedural conferences. Do you find, having gone through the mediation process, you cut through some of that pre-hearing case conference procedural issue type of part of the process?
Absolutely. two things are normal. The first is that parties may well resolve some issues in the mediation phase. I usually ask the parties for a list of issues for arbitration at the time it starts, because I want to know what they think is still outstanding, and I don't want to miss anything. But I don't want to backtrack on deals they've already made in the mediation phase.
I'm going to turn now to the terms of appointment, which are on your screen. But just for those who are tuning in, it's about 12:31. If there are any questions I haven't asked of David, and there are questions that you have, please feel free to put them in the chat box or in the question and answer, the Q&A box. So I'm going to scroll through the mediation arbitration terms of appointment. And one of the things that really struck me about this, David, when I read it, is the clear division between the Med process and the arbitration process, as you've explained, and the opportunity for parties to make an objection about whether your role, in their view, has crossed into a role in which you're no longer able to maintain your independence. And the idea is, now's your time to complain. If you waive that complaint, we're moving on, and you can no longer raise it, which is really critical for protecting the process.
Totally agreed, Lisa. The one thing I would say at the beginning is I'm not the sole author of this document. This is a document that's been created and amended by a whole bunch of people, including yourself, over a period of 2 or 3 years. I don't think it's a final document. It's just really something you give to the parties to make sure that they've thought about the issues that are likely to come up.
I've got a question in the Q&A box. Would you conduct a Med ARB with one party self-represented?
Absolutely.
I thought you were going to say absolutely not. Explain.
Well, they're there for a reason. They've agreed to the process, for one. If I think that person is being disadvantaged, I may conduct it entirely differently. But if people are there and they want to be there, I'm prepared to hear them. I had the advantage early in my career of practicing family law for about 10 to 15 years. And so I'm pretty used to the fact that people show up and don't have counsel. It's not the ideal situation. I would certainly like people to have counsel and be represented, but I'm not afraid of the fact that they're not represented.
That answer surprised me. Interesting. I'm not sure a lot of people in your position would feel comfortable with that.
Absolutely. I mean, I think a lot of people would shy away from that situation because they want the insulation that the council provide for them.
Yeah. So if we look at, I'm just going to scroll through some of the paragraphs. You've got essentially the recital, which talks about the process that parties are engaging in. Then you've got some of the legal stuff, which is this is a resolution process that's consistent with the Arbitration Act. We've got that in paragraphs 1 and 2. Then we get into what I think is the really interesting part. We've got a mediation section in which the parties are making commitments that the process will work in a certain way. And as I read it, what you're doing there is you're setting the expectations of the parties, which is that you expect this to be conducted in a mediation in the same way that a mediation would be conducted if there was no arbitration process attached, which is commitment to the principle of early settlement, candor in all communications, and confidentiality.
Absolutely. I want the maximum freedom in the mediation. I want the parties to understand what they're doing and what their commitments are in the mediation process.
Now, one of the things I wondered as I read this, and I may have missed it, but there's nothing, as far as I know, which says that parties must stay within the process. So do you allow, if a party says, you know, this mediation process did not go the way I wanted, I actually don't want to go to arbitration, so let's assume there's no arbitration clause in the parties' agreement. I'm not comfortable with this. Do you allow that, or are you somebody who says this is a process that the parties have agreed to, and in order to meet the commitments the parties have made to one another, to get this resolved, they must continue through to the arbitration.
My default on this is actually to try to force the parties to continue through to an arbitration. If somebody has a good reason not to do that, that's something I'm going to hear and take into account. I've only been in one case where this has happened, and I actually resigned because I was pretty sure I couldn't get the confidence of the parties in the arbitration phase. And I was pretty confident that they'd bring a Section 46 review. And it was easy because it was right at the transition from mediation to arbitration. And the parties chose another arbitrator by mutual consent, which kind of relieved me in a way, because I always worry that the party who isn't complaining is disadvantaged by the other party walking away at a certain point in the process where they said they were committed.
Okay, I've got a whole bunch of questions coming in here. On your transition agreement, do you have the parties sign it? I recently took a Med ARB case where the transition document was simply a notice listing what was agreed upon at mediation and what was left for arbitration.
Not good enough, in my view. Transition agreements don't have to be in writing, but you need to have some certainty as to exactly what issues are going to be arbitrated and what issues have been settled. So that's number one. Number two, you want some certainty that there isn't a complaint about the mediation process itself, and that the parties have waived that type of complaint before you start the arbitration. I have two ways of dealing with it. I either ask the parties to create a transition document, which I can assist in, or I put it on the record at the beginning of the arbitration and ask counsel to agree to it then. If you don't do that, I think you leave yourself open as a neutral to a complaint later on that it wasn't a proper transition.
And what does your typical transition document say?
It says we completed a mediation, we settled the following issues. The issues in Schedule A are the issues for the arbitration. The evidence from the mediation will not be used in the arbitration except for what's in Schedule B. And the parties waive any complaints about the mediation process. That's the bare bones.
And how do you or the parties decide that the mediation is over and it's now time to move on to arbitration?
In a lot of these agreements, the parties want a schedule, and what drives it actually are the arbitration dates. So you try to set the arbitration dates as early as possible in the process, and so the mediation can't continue forever. The second thing is it's pretty easy to recognize when you get an impasse you can't deal with in the mediation. You can settle 5 issues and still have 5 issues that are totally intractable and the parties don't agree on. That's a pretty good moment. And as a neutral, you can recognize that. The most difficult ones are the ones where you think that a party may want to do a deal in the mediation, but they're just dragging along. I usually bring that to a head by putting a deadline on the mediation process and saying we're going to finish by this date so we can protect our dates for the arbitration.
As you were speaking, I thought that many cases where we've all been involved in only settle moments before the deadline. And so having the arbitration schedule in place already does create some certainty and some time pressure.
Totally agreed. You know, when you start the arbitration, you have to have a solid timetable, you know, something you're going to work for so that you don't get hung up on preliminaries. And it does happen, you know, where somebody complains about production or somebody complains about new documents. It's going to happen in some cases. But as long as you give it enough lead time and you say everybody's on a short leash and we have to get this done, here's the timetable. Counsel particularly have been pretty good about that.
So just let me stop you there. So you deal with all the pre-hearing issues before the mediation is over?
Not always.
Okay.
Because I don't know what the issues for arbitration are going to be. But in that transition process, you have to have a really good grip on the structure of the arbitration, the issues, the timing, the preliminaries that need to be put in place, and so forth. It's just essential to managing the arbitration process.
I think that as you've talked today, I'm really appreciating your initial comment that the process can and should be very flexible.
Yeah. And you know what? I'm seeing a lot of flexibility in both phases now. A lot of young counsel have far more experience in mediations than they do in arbitrations. And they are very clever about how they run the mediation process and very strategic. That's worked out well for them and for their clients. A lot of older practitioners are more comfortable in the arbitration process, and they're more prone, as in fact I used to do it, just throw up my hands and say, well, this is useless. Let's just do the arbitration and get it over with.
So can you talk about kind of the strategic gaming of the system? What does that mean? The mediation part.
In the mediation process, there's now a very sophisticated approach to mediation. It has to do with the sequencing of issues. What do you want to do first? What's your strong point? What's your weak point? You know, do you want the mediator to talk directly to your client because your client isn't listening to you? You know, that sort of strategic thinking is now pretty sophisticated, and people come in on both sides with very clever approaches to mediation, very well thought out, very careful, and very strategic. Depends on the case, but you know, you see some really interesting things.
A question from the viewers. What about caucusing in the mediation? Do you do it?
Yes. It depends on the case. Sometimes it's not valuable, but most times it is.
And that's another reason why the transition term in your agreement is so important.
Yes.
Because that's an example where your role is very different.
Very much so. And, you know, I have sort of the anti-Vegas rule. I mean, if you don't tell me not to tell the other side, I'll tell them. But if you tell me not to tell the other side, I won't tell them. And I use that rule in mediation because it's been very valuable in terms of, for example, where the motivations are different on the sides. One side may be in it for the money and the other side may be in it for reputation.
One of the values, of course, in mediation is that you can achieve outcomes that aren't possible in arbitration. And that's kind of what you're talking about, you know, an apology, for example.
Very much so. And in some cases, it involves, in a commercial sense, does the name of the corporation change? Does the branding change? Does the do your suppliers change? That sort of thing can be really important to one party or another. And I can think of a whole bunch of other things that relate to the conduct of the business. But you have to be alive to understanding what the business is and what the parties want to achieve at the end of the day in the business. So it may not just be money. It may be something after tax recovery. It could be relationship with suppliers. It could be any number of things.
Another question, are you saying that the arbitration first procedural order is set out in the transition agreement or at the first arbitration case conference?
It can be both. I think that the first procedural order is really the transition order. What happens after that is probably a series of procedural orders confirming the dates, confirming what has to be done in what sequence and on what dates, and also reflecting agreements on evidence, agreement on documents, that sort of thing. That can come in a subsequent order.
I've had a question about whether I'll circulate the draft precedent after this session. I will. So those of you who don't have it will get it. Another question, have you had many cases where the process began as a mediation without an appointment for arbitration, but the parties asked you to stay on as arbitrator when the mediation did not give rise to an agreement?
Yes. It doesn't commonly happen when there's no agreement. But where the parties in the mediation actually agree on a number of things, and they're down to just a few issues that are left over, they don't want to invest in the learning process of a separate arbitrator to get those issues determined. So that's a pretty common result.
One of the things I thought about when I read your terms of appointment and this waiver of objection term, which maybe I'll turn to now, which is your paragraph 22. Have you ever seen parties or counsel use those kind of provisions strategically or tactically? Yeah, of course your answer is yes. How do you deal with that? And can you explain what that means?
It's actually pretty fact specific. I've had only one case that I've ever resigned, and that had to do with an issue of independence that arose after the beginning of the case. And fortunately, it arose right at the end of the mediation and before the arbitration got started. In most of those cases where somebody raises an issue, I want it dealt with then and there. If it's a jurisdiction issue, if it's an issue as to independence that I don't think is real and is being used for delay or something, I want to hear that then and there and get it heard and get a decision out, because that's going to trigger either a court process review or something else, or the parties will decide it isn't worth the fight and carry on. But it has to be dealt with then. Okay,
so your paragraph 22 said, based upon the mediator arbitrator's disclosure and declaration, and that's the typical statement that arbitrators make, which is they have no information that they think could give rise to reasonable apprehension of bias or etc. The parties each hereby waive any objection to the appointment of the mediator arbitrator unless any party objects to the continuing appointment or the mediator arbitrator at the commencement of the arbitration phase, they deem to waive any objection to the continuing appointment of the mediator or arbitrator.
Great clause.
Which is, we're finished the mediation process. We're now moving into the arbitration process. If you don't make an objection right now, you've waived the right.
I usually bring this directly to the party's attention at that time. And, I ask for it on the record at the beginning of the arbitration, whether or not any party has any objection to me continuing an appointment or any complaint about the mediation phase.
And when you talked about a mediation arbitration process going in parallel on different issues, it seems to me that you can't lose sight of the importance of this kind of a provision, which may have to be signed or whatever at multiple points in the process. Is that common?
Multiple is probably excessive, but certainly more than 2 or 3 times.
It also seems to me that given certainly the mediation phase, you're probably ensuring that the clients, the parties themselves, are involved in a way that in procedural meetings, etc., in a way that they are often not involved in just an arbitration process. Is that common?
It depends on the case and the counsel. Some counsel control their clients better than others.
And perhaps the sophistication of the parties.
Yes, and also the magnitude of the dispute. Some disputes are pretty personal, and some disputes are actually basically totally commercial, just about money.
That's interesting. I noticed that in your terms of appointment, which I'm tantalizingly talking about, and although some people don't have it before them, you haven't strictly followed the ADRIC Med ARB rules, and I spent a lot of time talking about those in the last session. Can you explain that?
The Med ARB rules, and I was on the committee that drafted the rules, we recognized that this process might be Med ARB Med, it could be any number of things, but nobody could agree there wasn't a consensus on the committee about whether to address those directly. So we decided that we would proceed with what we thought was the plain vanilla version of Med ARB, which is mediation first and arbitration second, and try to get the principles right for that so that people could go back to those rules and use them or adapt them if the parties wanted a more sophisticated process. I've never been appointed, and in fact, I've never used the ADRIC Med ARB rules as a pure process. I think it's too simple for most of the cases I'm hearing, but it does have great principles in there and principles that were agreed upon by some very sophisticated people on the committee. So I think it's the lowest common denominator consensus on Med ARB.
Yeah, when I reviewed your terms and I compared them to the rules, I thought that those principles were intact, and primarily this transition idea, which seems to me is absolutely pivotal in ensuring a fair process that all the parties are comfortable with.
Yeah, and it's important that the parties understand that at certain points in the process, they have the right to complain.
I'm winding up, folks. What about the promise that we make in arbitration generally, and that is that we're going to get a process that is speedier and less expensive than whatever is offered by the courts? Is that still the case in your view when Med ARB is being used in whatever form?
Generally, yes, but let's break it down a bit. Is it less costly? Probably not. Is it more effective? Very likely more effective than the court process. Is it speedier? Yes, it's a lot speedier. And finally, do you get a person in the role of Med Arbitrator who is a better person to resolve your overall dispute than you might get by chance in the court? That's not to say the court doesn't do a good job, but you get to pick that person and you get to pick somebody with the expertise you need. Very valuable if you're trying to really resolve a dispute as early and as effectively as you possibly can.
All right, that's my last question for David. I think a lot of the questions that I asked are found in his terms of appointment, which, as I said, will be circulated for those of you who don't have it already. And what I'm understanding from David is that even this agreement is flexible depending upon the process that you and the parties agree on.
Yes, I should emphasize to people that this agreement is just a starting point. In a sophisticated commercial process, I would expect this agreement to be expanded and contracted considerably by good counsel.
And are there new agreements that may get entered into as the process evolves?
Yes, but quite often it's just done by procedural order. So the parties will come to you and ask you to put on your arbitrator hat, create a new procedural order, even though you may be in the mediation. And it could be done easily by agreement, but quite often the parties want a consent order.
This process sounds fascinating to me. And I thank you very much for offering a glimpse of how it works. It is very clear that it's a different process than simply having a mediation in advance of an arbitration, and the expertise of someone like you is absolutely critical to ensure fairness of the party. So thank you so much for sharing your time with us. We've had lots of questions. Is there any last word that you want to share?
I would like to say to people that you should try it. If you haven't tried it and you're feeling a bit intimidated by the fact that the process is something that could be a bit more difficult than the simple mediation followed by an arbitration, get a hold of somebody who does this frequently, and not necessarily me. There are, quite a few really excellent people, and think your way through the process just to get a really good feel for it. Because I think you'll be very pleased with the results you can obtain by doing it, and the flexibility it offers in a commercial world that really neither the courts nor a simple process really offer the parties.
And are you directing that comment to both counsel and to arbitrators?
Absolutely. you know, I've got to tell you, Lisa, and I don't want to take people's time, but there are people who are well suited to this process and are not well suited either to mediation and arbitration. One of my colleagues here, who I won't name, has pretty much decided that they never want to ever do this. And they really don't want to do any mediations. They just want to hear arbitrations. And on the other hand, I know a person who will not do this and only wants to do mediations. So it's just, you have to actually, when you're interviewing people for the job, ask them what their experience is and how comfortable they feel with the process.
And interview sounds like an important way to get the comfort that the person you're appointing has the skill and comfort to do it.
Yeah, just make sure it's both parties at the same time.
Yes, we've talked about arbitration interviews in an early session in Arbitration Boot Camp, and that is a whole separate topic. And if you are interested in it, you can look at my list of topics and tune into that Arbitration Boot Camp. Once again, thank you, David. What's up next? My next session will be on May the 15th, which is a Wednesday, not a Thursday. And the reason I've done that is I know people will want to get away for the long weekend. It's just before the Victoria Day weekend. The topic is case management arbitration. What is it? How can it be used to get parties to trial faster and jump ahead of the queue waiting for a trial date? It's not something I've covered before in Arbitration Boot Camp, but it's something I've had a lot of inquiries about as people become increasingly frustrated at the pace at which court litigation proceeds. So once again, thank you to David. This is the end of the session, and thanks for all the questions. Have a great day.
Thank you all.
So David, people are signing out, and thanks, David.